Hi, I'm Irene Tansman, author of Abby and Arlene's Autism War. Today, I'd like to talk to you about supported decision making. And I particularly want to talk to you about a bill that's currently being considered by the Committee on Children, Families, and Persons with Disabilities in Massachusetts. That is Bill S 155 and Bill H 261. For my viewers who are outside Massachusetts, you might be interested to hear what I have to say in general about supported decision making. Now, when I first heard about supported decision making, I figured, well, that's a nice idea for people with mild disabilities to have some kind of an alternative to guardianship. I didn't think it applied to me because my son is very severely impaired, and of course he needs a guardian. And also, his guardianship was already adjudicated by the court, so I felt that it didn't really apply to me, and I didn't pay much attention to it. But then I later learned that yes, in fact, it does apply to my son who has severe autism and intellectual disability. Uh, that it does apply to him, and that um, that guardianship can be reopened at any time. So let me talk a little bit about supported decision making and guardianship. When a person turns 18, they are legally recognized as an adult, able to make healthcare, financial, and legal decisions. If they are unable to make these decisions, our state and other states as well have guardianship laws so that a guardian can be appointed by the probate court to act on their behalf. Guardianship laws are currently under attack by advocates of supported decision making. They want to make supported decision making the default, and you have to prove that supported decision making is insufficient in order to get guardianship. This is going to place a heavy financial burden on families who need to seek guardianship. The legal costs will be increased because you will have to prove that supported decision making is inadequate for your loved one. Now, supported decision making is an alternative to guardianship that enables individuals with disabilities to make their own decisions with the support of other people. Unlike guardianship, which transfers decision making authority to a guardian, SDM allows individuals to retain their autonomy while receiving assistance to understand and communicate their choices. So, at this new bill, which could become law, will affect those who are turning 18 the most, because though in their transition meeting, they will be telling the DDS will be telling the individual that they have the opportunity to make their own decisions. And some folks are going to be going to think, oh well, now I want to make my own decision, but might not be able to actually do that. So it'll affect those people the most, the people who can express that they want to make their own their own decisions, but don't have the ability to really do that. But it will affect all of us. It'll affect those people who are looking for guardianship, those people who are teenagers, 17-year-olds, the most. Those who can express that they want to have supported decision making, but they don't really understand, and they can't really make their own decisions. It's going to affect them the most, but it will affect all of us. It'll affect all of us because even someone who is very severe is going to need to prove that supported decision making is insufficient. Now, the Penn State Law Review had an article, and I'll place a link in the description below, um, uh, uh, an article about supported decision making and whether or not it's a viable alternative to guardianship. And I'm going to read a quote to you from that article. It is impossible to know whether supported decision making empowers persons with cognitive and intellectual disabilities. Furthermore, there is reason to be concerned that supported decision making might have the opposite effect, disempowering such individuals or making them more vulnerable to manipulation, coercion, or abuse. Now, there is a clause in the proposed bill that says that a supporter shall not participate in any life decision in which they have a conflict of interest. And of conflict of interest is in the eye of the beholder. They do not specifically mention the DDS or corporate providers. So it could be a supported decision-making teammate could be a corporate provider or the DDS. So we know that supported decision-making might not provide sufficient protection for people with severe intellectual and developmental disabilities who cannot communicate their wants and needs. Supported decision making could leave individuals vulnerable to exploitation by unscrupulous supporters that might take advantage of their trust. Implementing supported decision making effectively may require significant resources and training, which may not be readily available in all communities. We're facing all kinds of cuts. We're going to have supported decision making, but we won't have what is needed to really implement it correctly. In some cases, guardianships might be the most appropriate option for the well-being of the individuals with severe disabilities. I already gone over the legal costs. COFAR has done extensive research on how to obtain pro bono or low-cost legal representations for families caught up in legal disputes with the Massachusetts Department of Developmental Services regarding guardianship in probate court. They have not found any resources for families unable to pay for legal fees in disputes in probate court. So you are on your own in terms of proving that supported decision making, the default is not appropriate for your loved one. So I hope this information on supported decision making has been helpful to you. Please contact the people that I have in the description below, and I'll see you on the next video. Thank you for watching.